Hello, I'm Natalie McSherry, the president of the Maryland State Bar Association. For 125 years, the Maryland Bar Association has been the home and the voice of the entire legal profession in Maryland and beyond. We continue to serve over 40,000 professionals around the state, attorneys, judges, paralegals, and law students. We connect our members and the public with important leaders around the state and talk about the issues that matter to you. In this election cycle, we've already conducted interviews with gubernatorial candidates and will host debates with those candidates this summer at our legal conference in Ocean City and again in the fall. My co-host today is Bobby Zirkin, former state senator and an attorney who works with the MSBA on our advocacy efforts. Our current Attorney General, Brian Frosh, is retiring after an incredible career where he has served Marylanders on the local and national level and had an excellent relationship with the MSBA and the MSBA's Access to Justice Commission. We look forward to having the same with the next Attorney General for the great state of Maryland. And to that end, we are meeting today with Mr. Michael Peroutka, who is one of the candidates to be the next Attorney General. Good afternoon, sir.
Good afternoon, thank you.
To start off, as I said, the Maryland Bar Association is the largest statewide association representing attorneys across the state. Attorneys at all different levels of their career. We have law student members, young lawyers, more senior and seasoned lawyers as well. So for the benefit of those lawyers who are our members, can you tell us what your practice has been thus far and how that prepares you for the role of Attorney General?
Well, thank you. And again, thank you for hosting this series of conferences or interviews. I appreciate being with you. For about 27 years after I passed the bar, I was a partner with my brother Stephen, in a law firm where we specialized in what we called creditors' rights. We had a general practice, but most of our practice was in what we call creditors' rights. And that was a really wonderful time in my life. It was a very real privilege to be able to actually work with family, with my brother. And my brother always said, if you can stand back to back with somebody you can trust, you can take on the world. And my brother was a wonderful partner. And when I left the law firm, actually, when I won the primary for the council seat in Anne Arundel County, when I won that election in 2014, I became a councilman and enjoyed that. And about that time is when I retired from the law firm. So, and I've been for about the last 20 years teaching and studying both the Maryland Constitution and the Constitution of the United States. It's really my desire to return the state and return our culture to a constitutional form of government and an understanding of what law is and what law isn't, because I feel like we've suffered through 2 years of great lawlessness on the part of government, and we need to return to lawfulness. So, don't want to get ahead here, but that's why I want to run, and that's why I think I can serve the people of Maryland in that way.
Where have you been teaching?
Well, I helped to found something about 22 years ago called the Institute on the Constitution. And the Institute on the Constitution stresses the fundamental principles on which America was founded, what we refer to as the American view of law and government, that there is a God and our rights come from him. And the purpose of civil government is to protect God-given rights. And that's essentially a paraphrase of what the Declaration of Independence says. All men are created equal. And it's that creator that endows us with rights, and the purpose of civil government is to protect those rights. So for many years, I think civil government has gotten off on a tact of doing other things rather than that, redistributing wealth being one thing, and we need to return to those fundamental principles. So the Institute on the Constitution teaches those principles, and actually conducts a course in the Maryland Constitution, which is interesting because neither law school in Maryland, there's 2 law schools in Maryland, as you well know, neither of them have a course of study in the Maryland State Constitution, which is kind of unusual because everybody who graduates from there, assuming they pass the bar, takes an oath to the Maryland Constitution, and then they go on to become judges, and some become legislators, et cetera. And there's no systematic study of that document. So that led me into this idea.
So the studying and teaching of the Constitution that you've done has been within your own institute?
Yes.
Who attends those classes?
People from actually from all over the country. Our materials are used all over the country in homes and schools and basements and town halls and churches, etc., and all manner of places. We provide a course of study both on the U.S. Constitution and on the Maryland Constitution that is designed to be kind of turnkey, that you don't have to really teach the class, you can host it with.
Oh, okay. So this is not an accredited institution of any sort. This is.
It's like Harvard. We accredit ourselves.
I see. Okay. I think Harvard gets accredited by the upper schools, but anyway.
Well,
yeah.
And at least for many years, Harvard was its own accreditor. So yes, it's a matter of.
So what do you see as the role of the Maryland Attorney General?
Well, look, let's go to the Constitution. The Constitution gives basically 4 jobs that I can see in Article 5 of the Maryland Constitution. It gives 4 jobs, and that's to represent the state in appellate court, be it the appellate courts of the state or the federal appellate courts or the U.S. Supreme Court, where the state is a client on either side. And then also it's to investigate and prosecute matters that are either called for by law or asked for by the General Assembly or asked for by the governor, requested. And then it's to assist the state's attorneys. And then the last is to render opinions. So when asked, by the legislature or by the governor. So those are the functions of the Attorney General constitutionally.
Well, and of course, over the years, the Attorney General has taken on the representation of the state in all of its very many state agencies as well. Would you include that as part of the role of the Attorney General?
Well, as it's defined in the Constitution, yes.
Okay. So in those instances, do you see the client of the Attorney General being the governor, the legislature, or someone else?
Well, it can be all of them. It can be any of those. Again, they're specified, in Article 5, which deals with the Attorney General and then the state's attorneys as well.
Well, what if and I'm just thinking out loud here, because we have redistricting going on right now, and the governor and the legislature have different opinions. Which one would be the client of the Attorney General in that situation? Well,
I think the Attorney General would have an obligation to what he takes an oath to is actually the Constitution. So he would have to make some provision to do that. Although the Constitution says his clients are the governor and the legislature, and they are, his allegiance has to be to the document itself, because that document is really we talk about having consent of the governed, and that document actually represents the vehicle by which we give our consent, the people give their consent to the government, to be governed. And if the government acts within that document, then it is acting with consent of the people. And if it acts outside that document, then it's acting without the consent of the people. So I think questions like that have to be judged by what does the document say and where's the allegiance. So
Attorney General Frosch, during his tenure, has done work in Maryland on behalf of its citizens and also taken on some more national causes, such as the treatment of children at the U.S.-Mexico border, the emoluments cases, seeking to block the Muslim ban, that sort of thing. If you were elected, would you continue to pursue actions like that on behalf of the state of Maryland, or would your focus be different?
Well, once again, I guess like all great legal answers, the answer is that depends. And that depends on what is asked and what is authorized. Again, the allegiance, when we take an oath, we take an oath to the document, and that's where our allegiance is. And so the question would be, is that a function that the people have given the Attorney General? And if it is, then that would be studied and considered. But if it's not, then to do that would actually be to violate the law. And I would never want to use the position of Attorney General to violate the law.
So if it's not expressly provided for in the state constitution, to do it would be a violation of the law under your perspective on that position?
Very well, it could be. Yeah. It could be. That document, it's a document of limited and enumerated powers, just like the U.S. Constitution. And so that's what we don't take We don't take an oath of allegiance to a governor or to a president or to a bar association or to, you know, we take it to the document and we take it before God. So that's where the allegiance would have to be.
I'm sorry, we take it to the document and
we take it before God. I mean, an oath is something.
Ah, okay.
An oath is something in which you're actually pledging your welfare, and you're asking God to either reward you for keeping it or punish you for breaking it.
Well, aren't you also asking the law to reward you or punish you for breaking it?
The law?
Yes, sir.
Asking
I mean,
the law.
if you violate an oath, aren't you also assuming the obligation that the law can punish you for violating it?
Well, yeah. I mean, that's the whole. I mean, that's the whole point. The oath is not just a promise to the people, but my point in introducing the divine aspect of it was that it's an oath. It's an oath before the Creator, who is the author of law.
What about those citizens who don't believe in a specific Creator?
What about them?
How would you view an oath by them?
Well, my oath would require me to treat them equally and fairly under the law. An oath by them would be, I think, would be a nullity because it doesn't. An oath is something you take before God, and that's the way our founders understood it, and that's the reason that they required oaths. Was because they wanted to make sure that whoever was taking the oath had an understanding of an eternal system of rewards and punishments. In other words, if somebody wasn't afraid of an eternal reward or punishment, then what would be their basis for being afraid of the people or having, you know? So that was why our founders wrote in that the oaths were required in the Constitution, into the Constitution.
So let me kind of take a couple of these questions and answers and see if I can. I'm trying to understand how it would work in practice. So let me give it, and just you
Sure.
were quoted, I know, and talking about public education and that our public education essentially should be eradicated. That this was a plank of the Communist Manifesto, essentially. But we do, in fact, have a constitutional provision in the Maryland Constitution for a free and adequate education, and lots of statutes on the books. Mm-hmm. As Attorney General, you believe that we should eradicate public education, but it's in the Constitution. So how is it that how do you marry what is your own personal belief that somehow the entire public education should be gotten rid of with the fact that it's in our Constitution?
Sure. I'm sorry,
let me just ask. And
okay.
You have to, as an Attorney General, you are constitutionally, legally responsible for representing the Board of Education. So what do you do with all this?
Well, it's a big problem. Let me begin the answer by talking about what my beliefs actually are with regard to that, and then how that would, how that would reconcile, which I think is your question. It's funny. I have been quoted, and I have said that the education system, public education, is a platform of the Communist Manifesto. It's one of the tenets, and that's true. As a matter of fact, since our founding, many of the tenets of the Communist Manifesto, many of the 10 planks of communism, have been adopted one way or another, if not officially, but that, you know, de facto in our country. It's interesting to note that the beginnings of what we call public education now started in the 1850s, and that era, 1850s, 1860s, by men named Horace Mann and Robert Owen and his son Robert Dale Owen and others. That names, Horace Mann is probably the most familiar name most people know. And their objective, they were socialists, and don't take my word for it. I mean, you know, anybody who hears this can do their own research. But their goal in starting the public education system was not to teach kids to read and write so much as to move them away from the, indoctrinate them away from the values of their parents, and to work against the Christian fundamental foundation of America. And they've been largely successful in doing that. We sometimes look at schools sometimes and think they're places that are maybe unsafe. They have to have metal detectors. They have to have police there. It's where a lot of bullying happens. It's where a lot of drug abuse or drug happens. It's where a lot of fights happen, where a lot of violence occurs, et cetera. And we see these problems with the schools. And we tend to say, well, the system is failing. But if you actually look back at what the system was designed to do by the people who designed it, it's actually not failing at all. It's really succeeding in that goal, which is to transform. It's a change agent to transform America away from a Christian worldview.
I know you could go on about that. I'm really interested, not in the history of it, although I went to public schools and I'm Jewish, so I'm trying to figure out how I fit into all that. But my question is, as Attorney General, you have an obligation, a legal and a constitutional obligation, if you're the Attorney General, to represent the Board of Education. Right. So regardless of your personal views of the history of public education, how is it that you marry those things?
Well, again, I thank you for your patience with me here, because what I wanted to do is explain that there's a foundational problem with public education with respect to...
I apologize.
No, I'm going to answer. I know, I'm going to answer. I don't mean to frustrate you.
No.
But yes, the Constitution of Maryland does call for, does provide for a system of education, as you mentioned. So it is constitutional. It actually, in my view, is something that does need reform. But that's really not my job. As Attorney General, that wouldn't be my job. My job would be to the best of my ability, represent the Board of Education. I'm not going to hide my personal views about that, but I would have views about other things in the Constitution as well. But again, my allegiance is to that document because that represents the will of the people.
Okay. I want to ask about...
Sorry for the long answer.
No, not at all. No, I mean, it's...
But I really needed to say the first part to say the second part.
Another issue which is pretty hot down in the General Assembly right now, for reasons that it's in the Supreme Court and there are court cases that are rolling around the country, is the issue of abortion. So Maryland, regardless again of your personal views of it, have taken a very strong stance on the side of what is considered pro-choice. We have, and it's possible that by the end of this legislative session there may be a constitutional amendment on kind of putting that into the Constitution. Whether or not they do it, there's already law, statutory law in the books on the issue. You have had some very strong commentary on that, including saying that moms that seek abortion should be jailed, and that essentially Planned Parenthood are stalking children hoping that they get abortions. I mean, these are all historical things you've said. When you were,
I don't remember saying what you just said there, but
it was on something called The American View. I research and everything. But so I guess my question is, again, from a legal, moral, not legal moral standpoint, from a legal and constitutional standpoint, as the Attorney General, how do you marry your very strong views on this issue with the fact that Maryland disagrees with you?
Well, first of all, I don't maybe agree with your premise. I'm not going to accept your premise that Maryland doesn't agree with me. I mean, there are people that do and people that don't.
From a legal standpoint?
Well, from a legal standpoint, it depends on. I think what we then have to talk about is, well, what is law, and what are the requirements for something to be law? And I've written about this as well. And in order for something, I mean, when our founders were complaining about the Stamp Act and the Tea Act and the things that Parliament was doing, what they said was, you don't have the authority to do this, and so it's a nullity. They called those things in the Declaration, by the way, they called those things pretended legislation. They didn't call them law, and if you violated them, they called it a pretended offense. So if you take that understanding, the two standards that make things, and this is from Blackstone, two standards that are required for something to be law is it has to be, on the temporal side, it has to be consistent with the Constitution. It can't violate the Constitution because, again, as we said, that's the That's the vehicle that sets forth the consent of the governed. And it also can't violate the moral law. And our founders founded this country on the law of nature and nature's God. So,
according to who? According to you?
no, according to the Declaration of Independence.
No, I mean moral according to you, because I can tell you, like, my rabbi, right, may disagree with you and on some significant numbers of issues. And so who gets to determine what the moral law is? You?
No, your rabbi and I would probably agree that the moral law is set forth in Scripture.
Well, here's my
In
question.
God's
though.
word.
If Maryland has a law and you're the chief legal officer, I guess my question is, because there are a lot of issues like this, who are you to make a determination as to whether or not it's a nullifiable law or it's an immoral law? Because I can tell you, having been down in the General Assembly for 21 years, I can tell you everybody has their own opinions about what's moral and immoral, and they're all right and they're all wrong. But I guess your belief, and tell me I'm wrong, your belief about how this should all work is that you've made a determination as to what's according to God, and that somehow that should have some dictate as to whether or not you decide to, you know, agree or disagree with laws that are made by our General Assembly and our governor.
Well, it's not me personally. I mean, you're phrasing it in such a way that who am I to do it personally? I'm not the lawmaker. I'm not the lawgiver. But you know, again, our Constitution begins. The very first sentence of our Maryland Constitution says that we, the people of Maryland, are grateful to Almighty God for our religious liberty. So the idea is not to impose my beliefs. The idea is to follow God's word and God's law in the carrying out of my duties. And I think your rabbi would agree with me.
Can I ask you a question?
Sure.
So let's take the statute that Bobby referred to, which is the statute that says no one can interfere with the right of a woman to choose whether to complete a pregnancy or not. Are you saying that that statute is a nullity?
Yes, I am.
So,
simply put, yeah.
Okay. So if you were the Attorney General of the state of Maryland and someone challenged that statute, as the Attorney General of the state of Maryland, what would your obligation be?
My obligation would be to protect life, the very first.
Not to defend the statute passed by the legislature of Maryland.
I think the higher calling would be to protect innocent life. There's no statute that can. You have no right to do what God says is wrong. Rights come from God. What God says is wrong, and I mean and I say rights come from God. That's not my personal belief.
Understood.
That's the foundational principle of American law and government.
And different people interpret, you said the scriptures, differently, do they not?
Sure.
Okay. So whose interpretation prevails if you're going to say the interpretation of scripture determines whether a statute is a nullity or not?
Well, in that case, it would be who the people have elected to make certain decisions. That would be.
But who the people elected was the legislature, and they passed the law.
Well, again, the confusion is trying to take the moral law and make it my law or your law or his law or whatever. That's the wrong focus. I mean, I don't think that's the right way to approach the question. The question is what does God say? What do the Ten Commandments say? What's lawful? See that again, as I was saying before, in order for something to be lawful, it has to not only meet the bounds of the Constitution, it has to meet the bounds of what I'm calling the moral law.
And I understood that, and that's why I asked you whether different people could interpret the moral law differently, and I thought you had agreed that they could.
Different people could have different ideas about it, but on questions such as thou shalt not murder, God's word is clear on that.
Well, God's word isn't entirely clear because we have justified wars, right?
No, but that's not murder.
It might take my issue. You know.
Well, that's not.
I think, but exactly.
I'm defining murder as the taking of an innocent life.
Taking of life is not always murder, right? Because you just said war is not murder.
No, they're justifiable homicides, of course, yes. They're I'm not sure homicide's the right word there, but they're justifiable killings, yes, absolutely. But probably the most dangerous place that anybody can be in America now is inside the mother's womb, because the innocent life there, the child in the womb, no matter any other circumstances, has not faced a grand jury, has not been indicted by a grand jury, has not had due process, has not faced being convicted by a jury of its peers, and yet its life is being taken. That needs to be defended, and I would defend that as the Attorney General. Yes, ma'am.
But you would defend that over the validity of a statute passed by the legislature?
If a statute sought to counter that, then it would be what our founders would call pretended legislation. It would not be law.
And as the Attorney General, you would not defend that statute?
As the Attorney General, I would not defend that statute,
Okay.
no. I would, let me say it positively. I would defend innocent life. That, I think that's the
But I think
primary purpose.
of the two choices, you have the statute or what you see as the innocent life.
Well, what is innocent life? Yeah.
Well, we could go on forever about when does life begin, right? The theological arguments go on
Well, you might
forever.
go on forever. I'm pretty sure about it.
Well, I understand your belief is very clear, but others might
Yeah.
not agree, correct?
Well, of course.
Yeah.
So let me ask you about.
Others don't agree.
On that we agree.
Let me switch
Yes, ma'am.
topics for a second. Some months ago, a few of my former colleagues decided to write a letter to the governor of West Virginia asking if somehow they could secede to the state of West Virginia, a couple of the Western Maryland delegates, which was quickly, by the rest of the legislature and the rest of the Western Maryland delegation. They said this is outrageous, and it put a quick stop to it. It did make me think about some of the things that I do remember when you ran for county council. Remember hearing about some of your past views, or at least associations with individuals who had past views about secession and the Southern secession from the United States. And so let me just ask you in that vein, like, I guess it's kind of an elephant in the room, with you running for an office, your past association with the Southern, not with the Southern Poverty Law Center. I'm sorry, I apologize.
They wouldn't want to
right,
associate
the
with
League
me.
of the South, I think it's called.
Right.
And so their main view, or one of their main views among others, are secessionists of the southern states. And I guess it did make me think, it wasn't really a relevant question until this thing came up with individuals wanting to secede from the state. And so I guess running for Attorney General, I guess this is a good opportunity I would have hoped or assumed for you to disavow this organization that you were a part of before 2014, their views about secession and your past views about secession and white secession and so forth. Can you clarify
White
this?
secession?
Can you clarify this?
Yeah, let me try to do that, because there's a number of things you talked about there. First of all, the very first sentence of the Declaration of Independence says, when in the course of human events it becomes necessary for a people to dissolve the political bands which have connected them with another. That's secession. And that's what that is. That's what that sentence says is, when secession is necessary, or when secession happens, then we ought to declare the reasons why. That's what the sentence goes on to say. For a decent respect for the opinions of mankind, it requires us to say what are the reasons. So secession is as American as the first sentence of the Declaration of Independence. And what I mean by secession is the right of people to self-govern. People do have a right. I mean, our country is based on the fact that people have a right to self-govern, and my association with the League of the South actually occurred because at the time I was I was learning and studying and thinking very much about the overreaching and the fact that our central government has gone way beyond its constitutional limitations in many, many ways, and that's what that was my kind of kinship with the folks that I met from the League of the South. There was, I see no reason to disavow them. I left the organization when some leaders, some of the people there who were principally one person who you couldn't separate him from the organization, had said some things against interracial marriage, and I didn't agree with that, and so I left the organization when that happened. But as far as disavowing. I don't think I want to disavow anybody. I want to say why I was associated with them. It had to do with complaints about government that got out of control, and I agree with them on that. When some statements were made by leaders, not by the organization, but by particularly one leader, that had to do with something I didn't agree with, which was his statement against interracial marriage, I left the organization. Simple as that. No big deal.
So,
no, I don't disavow anybody. I mean, I just explained that's my situation.
So my question was really about secession. So I know what the Constitution says. I understand the underpinnings of it, the historical underpinnings. But we had 3 delegates, or a delegate, who wanted to take 3 counties and give it to West Virginia.
I'm not familiar with that issue, so I apologize. But
It's okay. But like, what are your thoughts now on? I mean, you were involved, and I think pretty heavily involved in an organization that believed that the South should secede.
Well,
you said that Maryland. I think your quote.
Not so much
that
the South should secede, but that
we
they
would have
had
seceded if they had. You were talking about Maryland. You said that when you were running for president, you said that your home state of Maryland was below the Mason-Dixon line, and that you were still angry that they hadn't seceded.
No, not angry that they hadn't seceded.
Referring to the 1861 arrest of pro-Confederate members of our General Assembly,
which
we hear about, heard about during the. So, where are you on this? I mean, like, do you? Well, I assume you don't still think that the South should secede from the United States of America, right?
It's not whether I think that they should or shouldn't. That's not really up to them. I think I'm more interested in the question of do they have the right to self-government? If in fact the contract they made with the central government is being broken by the central government, it's not unlike if you're in a marriage but it's a shotgun marriage. You're forced to be part of the marriage. I mean, if somebody was being abused in a marriage, would you agree that they should separate? And that's kind of the way I see that question.
So, as the Attorney General of Maryland, I'm not saying that anybody. I'm sorry. I'm not saying anybody should secede, and I'm not. But if you're asking me, I know there's some counties in California, I believe, Northern California, that want to create a new state or whatever. I think that all other things being equal, they have the right to self-government. And if the people desire to be separate, then they shouldn't, by a shotgun or by the force of arms, be forced to stay in a union that violates their rights. So if Maryland, the General Assembly, got together, over what would seem like a lot of beers, and decided that they wanted to form their own country, right? We don't like what the federal government's doing. We clearly can't stand with Virginia, West Virginia, and so the state of Maryland and the state of West Virginia decided, after a football game, decided we want to go secede from the union. You think that that's a legal thing to do? That Maryland and West Virginia, or the entire South for that matter, should be allowed to go secede from the union?
Maryland is its own country, properly understood. I mean, the United States is a union of states. It's a contract. The Constitution is that contract. So Maryland and Virginia are. I mean, when the Treaty of Paris was signed, after the War for American Independence, there were 13 states. I mean, all those states had the same legal standing, and nothing's ever happened that I know of to reduce that legal standing. They've joined together in a union. And some states, for example, New York and Virginia, I'm pretty sure is one. I think there are 3 states, and they would include maybe North Carolina, Virginia, and New York. They all said at their ratification of the Constitution that if, in fact, they wanted to remove that, they would, and they could. They reserved that right in their ratification of the Constitution. So I'm not saying anything new. People have a right to self-determination, a God-given right to that, and Maryland and Virginia are, well, Virginia is a Commonwealth, but they are individual states. They've just formed a union.
You mentioned earlier that when government overreaches, it's not valid. That probably wasn't your word, but can you explain how you believe, for instance, the government of Maryland is overreaching, if you believe that it is?
Well, it's a great example in the last 2 years. The last 2 years have seen lawlessness from the top of our government in Maryland. I mean,
can you give me some examples?
Sure. The lockdowns,
so the public health measures that
the public health, sure, the public health. Well, there's nothing wrong with public health measures, but when they violate people's rights, they're not allowed.
So how would you institute public health measures that wouldn't violate people's total freedom? I mean, freedom is not total, right? You always are subject to some restriction on your
But don't change the subject now. We're talking about constitutional rights.
We are talking about constitutional rights, yeah.
Right. So I'm sorry, your question is?
So you said that the closure of, you said the lockdown.
Lockdowns, mandates, face masks, none of those things are lawful.
Why are they not lawful?
Because the Constitution of Maryland gives the lawmaking power to the legislature. It doesn't, and we have what we call separation of powers. The duty of one branch of government can't be performed by somebody that's not in that branch of government.
And if the legislature has authorized the delegation of that power to, let's say, the Department of Health.
The legislature can't give the executive the authority to violate the people's rights. Can't give it.
Well, but you're lumping together the giving of the power and the violating of rights. So I'm saying if the legislature has the right to pass laws, which I assume you would agree with.
It does.
Okay.
If they're consistent with the Constitution.
And
then
one of the
law.
laws they pass gives to the Department of Health of the state of Maryland the right to protect the public health.
They could protect the public health,
Okay.
and I'm just off the top of my head suggest ways that they could do it by studying the situation, by giving health advisories, et cetera. They could advise people what to do, but to actually act to say that people can't assemble, that people don't have the right of assembly, or they can't practice their religion in church. They can't go. Those things are violative of people's rights. Now you can take health measures, but there's no COVID-19 exception to the Bill of Rights.
Aren't all of those rights subject to limitation for the protection of the public good?
No.
So
no,
yelling
no.
fire in a crowded theater is okay.
Well, you've just jumped to
But no,
a
that's
polar
just it.
example.
You're talking about
No,
restricting rights, and that's the commonly accepted
Well, actually,
example.
you do have. Well, let's play it out a minute.
Yelling fire in a crowded theater.
You can yell fire in a crowded theater. You just have to accept
Accept the consequences.
Right.
Okay.
Right. But there is no. But Article 44 of the Declaration of Rights, which you're probably familiar with, says that the provisions of the Constitution of the United States and of this state, being Maryland, apply as well in times of war as in times of peace, and no deviation therefrom or violation thereof, under a plea of necessity or any other plea, is valid. So yes, there is a public interest, and there should be a public health concern, but that concern can't violate people's rights. And Article 44 is about as clear as you can be on that.
Yeah, just on that front, I have heard you say that, and obviously, I mean, for openness, my brother-in-law passed away from COVID pretty early in this pandemic.
I'm
so
sorry.
I'm coming, thank you, from that angle. What court case in Maryland, because I try to follow all the things that come out of our courts of appeals. What court case are you relying on where the Court of Appeals, because I know there were some of the delegates had, and some individuals had filed some lawsuits. My understanding is that they were thrown out of court, and that there was not a Court of Appeals case that says what you're saying. Am I wrong?
I don't really know if you're right or wrong, but here's where I would suggest a change. I think the question you're asking, or one question that arises out of what you said is the Court of Appeals above the Constitution, or is the Constitution above the Court of Appeals?
Can I ask you a question? I'm
yeah,
so sorry.
No,
I have to
that's
interrupt.
fine.
Because this is the second time we've gotten into this kind of conversation. Your view of what the Constitution is, as learned as it may be for what you do, may be very different than mine or anybody else in this room. And it's not absolute, right? Like your view of the world and the Constitution and Maryland's law and moral law and things like that is yours. We have legislatures and courts that decide these things in a matter of law. And you've said a number of times today, well, I don't agree with that, it's immoral, or I don't agree with it, I think it's unconstitutional, even though your court said otherwise. How is it that an attorney general is not an autocrat? How is it that you marry those things? Like your role is to follow the law. And a couple times here today, like you accused Governor Hogan of being, quote, lawless. But the court said otherwise. And obviously public opinion polls say otherwise.
Well,
but more importantly, the courts say otherwise.
Well, if you say the courts say otherwise, you can tune in tomorrow to see what a court might say tomorrow. Courts reverse themselves and they say different things at different times.
But they haven't
now. But again, let me get back to my question. Is the Constitution supreme, which calls itself the supreme law of the state, is that supreme over a judge or a court decision, or is the court decision supreme over the Constitution?
But how do you decide what
takes precedence?
how do you
Who's the
decide?
arbiter?
Right.
Who's the
How do you
arbiter?
decide
Actually,
when the Court
everybody
of Appeals or the Supreme Court says something about what the Constitution says? How do you make a determination that they're wrong? You?
Well, they do it themselves, plenty.
Right, but if they disagree with you, for example,
well,
our Court of Appeals said...
I think I got your question.
Yeah.
I would answer this. In in the context of whatever your scope of authority is, you are supposed to know the Constitution, and you're supposed to know what it says and what it means. Now, that doesn't mean that everybody will agree at every instance. I understand that. But for a sheriff or for a police officer or for anybody or for an attorney general or for an attorney, anybody who takes an oath within their sphere of influence, within their sphere of jurisdiction, I should say, you're supposed to know what the Constitution is. You're not supposed to, in my view, I don't think it's proper to just kick the can down the road and say, well, I'm going to do I'm going to do this because my police chief or my governor or whatever tells me to do this, and I'm going to wait for a court to decide later. I think that's a dissatisfactory justice. That's not justice.
But how do we decide in the final analysis the proper interpretation of the Constitution of the state of Maryland if the Court of Appeals, the highest court of that jurisdiction, is not the final arbiter of what that document means?
Well again, I know that I'm saying something that's different from how you've thought about this, but what I'm suggesting is that the final arbiter is the Constitution itself. There will be, that's not to say that every decision will always be made perfectly, but this idea that we've accepted in America that whatever a judge says takes precedence over what the document says.
But, okay, but the document has words, and words are subject to interpretation. So are you saying each person is the final arbiter of their own interpretation
Not each person.
Of the Constitution?
With respect to the authority that they've been given by the people, yes.
But
in other words,
but it's their own interpretation that's going to decide what authority they've been given under your view of it, I think, if I'm understanding you right.
Well, we're struggling over this concept of whether or not there is just a standard for me or standard for you or standard for you, and there's no way to ever resolve that, or whether there are certainties. And as far as I'm concerned, there are, when Article 44, for example, of the Declaration of Rights says that no plea of necessity can be used to violate the provisions of the Constitution. I mean, I don't think that's up for much interpretation. You can ignore it, which I think has happened, but I think the language is pretty clear, and I think reasonable people will agree that the language is clear. But the real question I think we're kicking around is the state over the Constitution, or excuse me, is the court over the Constitution, or is the Constitution over the court? That's really what we're asking.
So
and the fidelity is, my fidelity as an Attorney General is not to any particular judge or any particular court. My fidelity is to the document.
So if your interpretation of the document differed, and come on, we all agree they can be interpreted, right? And if you're
we do, but where you're going with that logically, I think we disagree. But yeah, I will agree. I will agree that different people have different interpretations.
And as the Attorney General for the state of Maryland, if a statute or a provision of the Maryland Constitution goes all the way up to the Court of Appeals, and the Court of Appeals issues a decision one way or the other, we're dealing in the abstracts here. I'm not talking about any particular issue. As Attorney General, you think you would not have to follow the law as interpreted by the Court of Appeals?
I would always follow the law. What you're
I hear a comma at the end of that, or a but.
Might have been a semicolon maybe.
Okay, fair enough.
I would always follow the law. But if you think that the law changes and what the Court of Appeals says today or Court of Appeals says tomorrow, if that's what law is, then what you're doing is you're taking that individual that you're objecting to, that individual interpretation, and you're just giving it to a judge or to a group of judges.
Isn't that what we do in the law?
We do it with respect to cases and controversies. Yeah. In other words, cases and controversies come before the court, and the judge has the authority in the case of the controversy. But what he says doesn't make law.
But what he says decides the case or controversy.
It decides the case or controversy.
Before him or her. Right?
That's right.
Actually, I mean, that's actually not true, right? I mean, like they make law all the time from the bench, right? The statute has the law as it's passed by the General Assembly, and courts fill in from their decision making, right? It's case law, so that's actually not accurate, right? I mean, like at the end of the day,
no, actually, I believe
we can pass, for example, and I want to ask you about this, is same-sex marriage, but like there are all, and we talk about non-discrimination and things of that nature, but then there are individual cases that fill in the gaps, right? I mean, you have a general principle under statutory law that the General Assembly would make, and then cases and controversies come up because there are different interpretations, and unless the General Assembly,
Right.
not the Attorney General, but the General Assembly makes determinations otherwise and, you know, tinkers with it, it's the rest of it's filled in by the courts, right? That's the way that it works, right? I know that's not your kind of a law practice, but that is.
No, I disagree. I don't think that's the way it's supposed to work. I think de facto it might be working that way. But
that's how it's worked since England. I mean, there's case law
that's
that goes all the way back.
Case law in the way you're describing it really comes in around the 1880s in Harvard University with Christopher Columbus Langdell, and the idea that instead of looking to Exodus and Genesis for case, we look to the decisions of prior judges, what a judge said last week or last month or last year. So the whole case law method is not the method that our country was founded on. Our Madison, Monroe, Patrick Henry, George Washington, they didn't see Jefferson. They didn't see courts the way that you're describing with case law. I grant you that that's the way it's been for a long time.
I don't mean
yes,
I don't want to argue, but like,
no,
for example, just in an area such as dog bite law, which is as obscure as it gets, like there's a common law that came from Old England, like that has been passed down, what was referred to as the one free. That's long before what it is that you're talking about. There's common law that came from before the formation even of our country. So what you're saying is not accurate. I mean, there's been case law that came before we even formed a country that has evolved over the years from court to court. It's just not accurate what you're saying.
Well, I disagree. It is accurate what I'm saying. I believe it is accurate.
All right, I apologize. That wasn't much of a question. Let me ask you this. I feel like I'm back in JPR. Let me ask you this about another issue, which again is kind of different states do it differently. Maryland is pretty clear, and that's the issue of same-sex marriage and non-discrimination. And again, you've had some historical comments that would not be taken kindly to by certain populations in Maryland. Regardless, how do you see your role if a case in controversy comes up that requires you to go and defend Maryland law on an issue that you clearly think you think differently than the General Assembly? You've talked about the immorality and things of that nature of homosexuality, and that you think that Maryland's law passing same-sex marriage, I think you actually said at one point in time, maybe tongue-in-cheek, but you said that invalidates all of our law. But I guess my question is, you go before the Court of Appeals representing the state of Maryland, who absolutely disagrees with you on that. That was done by vote of
the state of Maryland.
The people.
What? The people. Well, there are a lot of people that don't agree. There are a lot of people that agree with me.
Maybe they do, maybe they don't, but the law says otherwise, and you represent the law in Maryland as an attorney general.
Well, but I would, I mean, you know where this goes. My argument would be that that's not law. It can't be law, because it violates Genesis, is it 1:22, that made the male and female?
I do, but now, so now we have a bunch of layers, right? Now there's the law as passed by the General Assembly and interpreted by the courts, and now you're like, well, I don't agree with that because constitutionally I disagree, so I'm going to do it differently. And then if I don't disagree constitutionally, I disagree God-wise.
It's not
so
me
you decide
what
the interpretation of God is.
What I'm suggesting is, in the American understanding of law and government, in our American system, and the documentation of this is there. There are two standards to determine whether something is lawful. One is whether or not it meets not what a court said, but whether it meets the constitutional limitations of government, and also whether it is it has to be harmonious with God's law. It can't. In other words, you can't make a law saying that everybody whose last name begins with Z, we're gonna shoot at dawn. I mean, even if you got a number of people to make such a law, and you got to, it would violate God's law. It would violate Exodus 20:13, thou shalt not murder. So that's the beauty of America, in that there is this, even the rights of minorities are protected because there is a higher moral law that's recognized. And to the extent that it's not recognized, we're in trouble. And we have chaos and uncertainty, and we have anarchy.
I apologize. Don't you see I mean, it's like, I understand that you are assured of how you believe these things are written, but I don't agree with you on some number of issues, let's say. And you're going to make a determination, even though the law may agree with my position on that, say on same-sex marriage, which is honestly one of the proudest votes I ever took. You think it's against God's law. Okay, I mean, you're entitled to your opinion, but the General Assembly disagreed with you, and so did the governor at the time.
Well,
and so
for
that's
years
that's in
okay.
our law.
I'm sorry,
and
I apologize.
It's okay, but who are you to make a determination, or anybody for that matter, as to what God says about it? Because I can tell you that's one of the things that my rabbi thought was one of the greatest things that he'd ever seen down there, and was down there when it passed. So the person who I look to for spiritual guidance does not agree with your interpretation of the Bible, whatever you say, whatever you quote. So how are you, as the Attorney General, to make a determination as to whose spiritual guidance is right and wrong? I mean, where do you get that authority?
Turn back the clock 75 years, just to take a number. At that point, the people of Maryland would have agreed differently, wouldn't they? The law, what you're calling the law, would have been different, right?
I'm not that old, but yeah, okay. I'll go with it. I'll
Same-sex marriage was not legal in Maryland.
I understand that.
Was not called
so the
legal.
law changed. Times changed. The law changed.
So was the previous way the law, or is now the law, or were they both the law?
Actually, they were both the law at the time.
Well, then the law could change back then, couldn't it?
Yeah, but that's. But
you don't see that as that.
No,
but what
I
I'm
understand that, but it's not your role to determine what's right and what's wrong as to what the General Assembly. It's not your determination as to what God would say about it.
I'm not claiming that it is. It's actually.
You kind of are.
What I'm looking to is a standard, and I'm saying that there's two standards, and they both need to be met for something to be lawful. You're calling things law. You're just going ahead and saying this is law because the Maryland General Assembly said so. Well, the Maryland General Assembly said this and that, and they might say something else next month, and the court might say something else next month. The idea that law evolves, like you're suggesting, is like a Darwinian view of the law. But I don't think our founders had that. I don't think America is founded on that understanding. That understanding is that law is fixed, and there is an absolute truth. That's why you can say things like, all men are created equal, and they're endowed by their Creator with rights. And it's the job of government to secure these rights. Governments are instituted among men. That's why you could say that, because there is a standard. What you seem to be wanting me to say is there is no standard, and I'll just go along with whatever comes out of a judge's mouth tomorrow or comes out of the General Assembly tomorrow. That I think is the throwing out of a standard. What I'm talking about is to uphold a standard.
But Mr. Peroutka, let me ask you this,
Sure.
because I think what Senator Zirkin is getting at is, and it goes to your very basic principle, as I understand it, which is that the Constitution is based not just on the written law, but on the law of God, as you have said. My problem is, as Senator Zirkin said, theologians can disagree on what the law of God says, just as we mortals can disagree on what the proper statutory law may be. But as lawyers and as the Attorney General for the state of Maryland, wouldn't you be obligated to defend the statutes passed by the legislature of the state of Maryland, regardless of whether you thought they were consistent with your interpretation or your theological interpretation of God's law?
Well, we're covering the same ground over and over here, I think, because what I suggest that you're confusing the fact that I'm holding to a standard that's different than yours or different than other people's, in that I'm holding that this is my standard, that I'm imposing my beliefs or whatever, and I don't think that's true, and I don't think it's a job of government to do that. I think there are standards that our law is based on, and they need to be adhered to.
And I'm just trying to figure out how they would apply if you were the Attorney General.
Well, they would apply consistent with my fidelity to the Constitution and my understanding of God's Word. Yes, they would.
Okay, I think we're getting the signal that we're out of time, though. It's been a fascinating conversation. There's lots more we could cover, I'm sure, if we had time. But I want to thank you.
Oh, you're very welcome.
For coming today. And
thank you very much. Appreciate your time. And
thank you for your time.
Thanks for your patience. Appreciate it.
Thanks.